As you may have heard, the Supreme Court handed down its ruling in Citizens United versus Federal Election Commission. Overruling a half-dozen precedents, it held, in typical Cheney speak, that the restrictions on campaign contributions by corporations are unconstitutional. Justice Kennedy argued that PACs, political action committees, formed by corporations, are separate entities and therefore do not count. I have investigated congressional corruption for over 14 years and can tell you that PACs receive money from corporations and their officers and pay it to senators and congressmen as part of a pay-for-play scheme. And yes, I do have the evidence. The president had an issue with the ruling.
But this week, the United States Supreme Court handed a huge victory to the special interests and their lobbyists, and a powerful blow to our efforts to rein in corporate influence. This ruling strikes at our democracy itself. By a 5-4 vote, the court overturned more than a century of law, including a bipartisan campaign finance law written by Senators John McCain and Russ Feingold that had barred corporations from using their financial clout to directly interfere with elections by running advertisements for or against candidates in the crucial closing weeks. This ruling opens the floodgates for an unlimited amount of special interest money into our democracy. It gives the special interest lobbyists new leverage to spend millions on advertising to persuade elected officials to vote their way.
What is more disturbing is that this ruling is a threat to the national security, as I will show in a moment. Hello there. Welcome back. Let me give you some background. This nation is dangerously dependent on foreign oil, supplied to a large degree by nations that are hostile to the United States. Indeed, in 2008, we became the volleyball of OPEC and a bunch of speculators when the price for gasoline jumped to over $4 per gallon. Chevron, Exxon, and other big oil companies made billions in profits. And no hand-holding or kissing made any difference. The gasoline price hikes continued for months and contributed to the recession, as well as to growing trade deficits. Energy independence, I have said that before, is a matter of national security. Not just because of the impact on the economy, but the crude logistic is wide open to attacks. I'm not sure you remember that GM had an experimental car, the EV1. It field tested. A car that could have made us independent from foreign oil. Until Big Oil put pressure on Wagner, GM's chairman, who promptly recalled all vehicles and had them crashed. And no, the reason for recalling them was not, as now claimed, because the cost of production, remember the startup costs, were too high. Toyota's Prius is a highly profitable car, as are other hybrids. Let me give you some additional information. GM acquired a controlling stake in Overruling, a company formed by the inventors of a battery type for which they received a patent. No sooner went GM into production of a battery-powered car when Chevron made an offer to buy GM's stake in Overruling, including all the patents. Now, why would an oil company buy the rights to a battery patent? For no other reason than to restrain the trade while not planning to manufacture the battery itself at all. Something Congress should act upon, but does not have the intellectual flexibility to understand. Need proof? Here it is. Mercedes contracted with Overruling and Chevron to have the batteries manufactured and delivered, and even advanced $6 million, followed by a multi-million-dollar investment in the design of a crossover SUV. When the car was ready to go into production, Mercedes demanded delivery of the batteries under their contract, at which time Chevron refused. That led to a lawsuit by Mercedes against Overruling and Chevron, at which time Chevron's chairman gave Chevron PAC $5,000 which Chevron PAC promptly paid to Jeff Sessions in return for ex parte contacts to the judge in the case. Jeff Sessions is Alabama's senator. After Chevron PAC paid the money to Jeff Sessions, O'Reilly, Chevron's chairman, promptly paid another $5,000 to Chevron PAC. A telephone call was made to the judge, who recused himself on the same day. I contacted the CEO of Mercedes USA and gave him the evidence of the payment to Senator Sessions, plus other information. But the CEO was too wussy to act on it other than having the lawsuit and the SUV killed. It is noteworthy, and typical I may add, that Sessions' ex parte contacts effectively killed the production of the Mercedes SUV in Alabama, Sessions' home state. Now, having established that Chevron restrains the trade acting as patent troll, and having no intention whatever to sell the Jeopardizes Ovonix batteries, it becomes obvious that Chevron's goal is to have the United States to continue to be dependent on foreign oil. If needed, it will pay whatever it takes to whoever can be influenced by money. Congress, for one. As of January 21, 2010, the Supreme Court indeed has opened the floodgates and thereby endangered the national security. Now, Alan Grayson has introduced legislation hoping to get around the Supreme Court decision. Except that his colleagues have seen the green light at the wall, money for the next elections, which brings Grayson's attempt at the very least in jeopardy. Now, if you have evidence that big oil has anything else in mind but profit, you can educate me. Need one?